What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Today's video comes to us from the TikTok user Law New York, and it depicts a traffic stop that was conducted by a deputy in Tom Green County, Texas. Now, I don't have any context as to when the actual traffic stop happened or whether the Law New York channel was involved in the traffic stop or whether they're just playing the traffic stop for the purposes of putting content on their channel. But at any rate, you should go over to their channel, give them credit for sharing it, and check it out in its entirety. With that, let's give it a watch and we'll come back and talk about it.
Oh, what are you doing? Okay.
You rolling, man? I let you way back.
What do you mean by rolling? I saw you.
Let me get your license, man.
Okay, well, I'm gonna hop out.
No, stay in the vehicle.
Okay. I pulled his gun on me and everything.
Okay.
Crazy.
Put both hands on hold, please.
Okay.
Both of them on the wheel. Remain there. Do not move, okay? Go to get the vehicle.
Sounds good. You shut my door. Will you shut this door?
Hey, man, hop out.
What are you doing?
Hop out.
Hold
Fuck.
up. You come up here and you pull your gun on me and then you rip my door open for no reason.
Step out of the vehicle.
What's your reason for pulling my door open?
Older truck, man.
So you just rip my door open because it's an older truck?
And you're rolling. People who roll have warrants.
I haven't rolled
They
anything.
have pot all over their pants.
I don't have any.
Like marijuana in your vehicle.
This is sawdust. Okay, sounds good.
Put your hands up.
Okay, so in typical police officer fashion, no, you can't get out of the car. You got to stay in the car because it's your idea. But 2 seconds later, I'm going to get you out of the car. It probably is a Fourth Amendment violation for him to just walk up and open the door, depending on what he would articulate in court. Of course, we don't have the context and we don't know what he might say. I'm sure it's nonsense. But nevertheless, you can't get out of the car unless it's my idea to get out of the car. If it's your idea to get out of the car, there's definitely an officer safety issue. If it's my idea to get you out of the car, I'm much safer, which is absolutely stupid. I have said for many years that Mims was one of the worst Supreme Court decisions in the history of our country, not only because of the fact that it gives officers essentially carte blanche authority to order people out of the car, and they can only really be hemmed up when they don't actually have enough sense to know what they're supposed to say about why they ordered people out of the car. Because again, remember, under the Pennsylvania versus Mims standard, the idea is that you are able to order a person out of the car who's already been lawfully stopped on a traffic stop without it being a further intrusion into their Fourth Amendment rights as a precaution for officer safety. But again, to me, that's a pretty hard argument to make when he tried to get out of the car on his own and you didn't want him out for officer safety, and 3 seconds later you can get him out for officer safety. Now, it sounds like there's maybe a different officer that he's talking to. Unless the officer went around the car, you can't tell, you don't have the context. So I don't know whether the same officer is now ordering him 30 seconds later to get out of the car that just told him to stay in the car, but it wouldn't surprise me. Or whether there's a second officer that is given the commands to get out of the car. And I guess you could make the argument that he didn't want him out of the car until a second unit arrived, if in fact there is a second unit. But again, we don't know that. So again, we do have Pennsylvania versus Mims here, which allows an officer to get a person out of the car without a further Fourth Amendment intrusion, so long as it is anchored to a precautionary move for officer safety. And again, I don't know whether this guy would have enough sense to understand that or not. The other thing that's kind of funny is that first he says you've got weed all over your legs. So the guy has sawdust on his legs, and he says, that's sawdust. And like, you can tell by his inflection that he's being genuine about it. Like, it's not, he doesn't have marijuana. But then the first thing that the officer takes note of or verbalizes was that he believes he has marijuana on his pants. And then he immediately says it smells like marijuana in your car, which again, I'm sure it probably doesn't, and he's lying because he just thinks that that's what he needs to say in order to be able to justify what he's getting ready to do. But again, the way he's going to move forward and conduct this traffic stop leads me to believe that he doesn't understand anything about what he is or isn't allowed to do, or maybe he doesn't care, but he's either clueless or doesn't care one way or the other and is just going to do what he's going to do. But let's watch some more.
On the vehicle.
For what?
Hands up on the vehicle, please. Let's go frisk.
You're not going to frisk. What am I under
Put your
arrest
hands
for?
up on the
What am I under arrest for?
I'm frisking you for weapons, Bubba.
Okay.
I'm not putting you in handcuffs.
I don't have no weapons.
Spread your legs, please.
You're going to touch all up on me, whatever it is. Yeah. Look at this boy. Look at this boy. He's getting all up on it. So what's the reason for the search?
For your mud flaps, man, being too short.
So you ripped my door open and frisked all up and opened my truck up for my mud flaps for being too short? Is what you're saying? Is that what you're saying? Yes or no?
Yeah, warrants.
Is that what you're saying? Yes or no?
Yes, sir.
So you pulled me over. What was the reason for the stop?
For your mud flaps, being too short. Pot on your edge of your seat, man.
There's pot on the edge of my seat.
Come here. You can now get back in the car.
I want to see all this. Yeah, for sure. But that, again, you rolled up on me and ripped my door open because my mud flaps were too short?
Yes, sir.
So that's normal procedure for you to just run up and rip doors open because the mud flaps are too
You have the
short?
car rolling, man.
I wasn't rolling. I got to a place where I could pull over so that people weren't stuck getting in and out.
There were people who roll, have drugs.
I wasn't rolling, doing anything. I was sitting there calmly cruising.
They're not too any good, man.
So I'm automatically bad because I didn't want to block the drive.
Okay, so this is actually pathetic. This police officer is completely incompetent. So this guy has done a really good job because he's actually way more equipped for this traffic stop than the police officer is. He's narrowed down the fact that the officer's probable cause for stopping the car was that he thought the guy's mud flaps were too short, which means that there was really no reason to stop the car at all. It was pretextual in nature. Then he says the guy was rolling, meaning that he didn't stop when the officer immediately wanted him to stop, which of course is BS too. And the guy tries to explain that, I tried to stop at a place where I felt safe and I wasn't obstructing traffic. And the guy's like, oh yeah, well, people who don't stop immediately have warrants or they have drugs or they're bad people or whatever. And this guy's doing a good job of calling out the officer. And this is what I'm talking about when I say that, it's one thing to be like completely disrespectful, cuss the police, be super combative to where they can sort of accuse you of being aggressive in a way that presents opportunities for them to use force against you. And then it's another thing altogether to just question them and sort of corner them on the answer. So he's doing some version of cross-examination that a lawyer might do by asking the guy questions, and he's getting some really good answers because all of this is bogus. So one, we've got a pat down that is unjustified. We now know that he ripped the guy's door open to try to pull him out of the car because he thought he was evading. But again, the guy wasn't evading. He was just trying to find a safe place to stop. So he opens the door figuring he's going to rip him out. And then maybe he thinks better of it. I'm not really sure exactly what happened or why. Maybe it was because the guy said he was going to get out, and then the officer was like, no, we can't let him have an idea as to what's going to happen. Maybe I'll change my entire game plan. So this is just complete silliness. But again, under the standards set forth in Terry versus Ohio, we know that in order to perform a Terry stop, and a traffic stop is a Terry stop, you have to have reasonable or articulable suspicion of a crime that has been committed, is in the process of being committed, or is about to be committed. So a traffic infraction or traffic violation counts, and so we do have a valid Terry stop if the mud flaps are reasonable suspicion of some traffic infraction. I'm not sure under Texas law. It's really not even necessary to explore that because everybody knows that the whole reason was pretext anyway, and it was bogus. But second to that, he gets the guy out of the car, which is fine under MIMS, but he pats him down, which is not fine under Terry. Under Terry, you have two bifurcated concepts. You have the Terry stop and you have the Terry frisk. And I've covered this in detail in a couple of my videos. But the Terry stop is based on the onset or the criminal activity that is afoot. And then the Terry frisk is based on a reasonable belief that the person is armed and dangerous. And so we have nothing here that would warrant a Terry frisk. We have a police officer who doesn't understand what he is and is not allowed to do, and so he's probably one of these guys that figures that every single time he gets a person out of the car, he's going to pat him down. That was me. That was me until literally criminal procedure in law school, and it wasn't because I was malicious or just wanted to violate people's rights. I just didn't know. That's what they trained us to do, and I didn't know. And I was literally sitting in criminal procedure class in law school thinking, holy cow, I did not know. I just didn't know. So I don't think this guy frankly cares, but he also doesn't know clearly that you cannot pat somebody down under the standard in Terry unless you have some facts that would give rise to a reasonable belief that the person is armed and dangerous. You got nothing here, at least as far as we can see. Well, now we've moved on from mud flaps to we're going to pat him down illegally, open his door illegally, and the shake that he thought was marijuana is not marijuana. Now he's falsely claimed that he smells marijuana in a truck that doesn't have marijuana, and he's in a bit of a spot. So let's see how this thing ends, and we'll come back and finish it up.
So what are we here for now?
I'm gonna be on probable cause search.
For what was your probable cause? Because my mud flaps were too short?
Odor of marijuana.
But there was no odor until after you ripped my door open or before?
It doesn't matter. You're rolling the window down anyway.
I didn't roll this window down. Not at all. I rolled that side down. See how it's down? This window's not up. He ran over here and ripped this door open and had his gun drawn on me. Absolutely. Is what happened.
Absolutely.
Right.
Absolutely.
So where's your probable cause at? Before or after you ripped the door open?
I opened up the door and it was coming from the car as well.
What car?
This pickup.
So it was coming from, so with the window up, there was odor of marijuana coming out?
Absolutely.
Is that what you're going with?
Absolutely.
Sounds good.
So, How much marijuana is in the vehicle?
I don't have any marijuana in there.
Okay.
I got sawdust in there, and evidently that's marijuana. There's no probable cause because you came up and just ripped my door open. Oh, nice. Now he's trying to get a tent ticket. He's going to try and get something today.
Okay, so there you go. We probably don't have anything. Now, the TikTok user did not say how the stop ended, so we don't know whether it ended in a citation or not. But you notice that the officer was up there trying to look at tent to see whether the tent was within the legal standard. So this is nothing but a fishing expedition. I mean, it started out with short mud flaps, and then it went to marijuana shake that was sawdust, and then it went to odor of marijuana, and then it got him out, patted him out, he had nothing. Now he's looking for tent violation. He's doing a probable cause search where probable cause does not exist. They literally have nothing that would establish probable cause. If it's true that he smelled marijuana, then that would be a probable cause search. But I have serious doubts that he actually smelled anything, because our driver here was very, very confident that this was sawdust on his legs and that he didn't have any marijuana. Now, I will tell you that as somebody who doesn't use marijuana, if somebody has used it even in the last couple of days, you can smell it. I mean, you can smell it. You can smell it from, if there's marijuana in the vehicle, you can smell it from 25 feet away, especially if the air conditioner or the heater's on in the car. So the idea that you can't, I mean, I've been on the roadway and had people drive beside me at a stoplight and I could smell the marijuana coming from their vehicle into my vehicle. So it's certainly possible that if there was marijuana in there, he would have smelled it. But the way that this thing played out and the layers of sort of BS of we started with one thing and we ultimately worked our way up to this idea that there was marijuana tells me if there was truly marijuana, it would have been mentioned right from the beginning, and I don't think that's what happened. And I do actually think, based on what the driver said here, that we have two officers, because he said that the guy opened his door and he drew his gun on me, and he was talking about he as if he was talking about another person. So I think the officer that's actually here doing most of the interview with the guy is not probably the officer that made the stop. In closing, this was a good video for us to sort of revisit Pennsylvania versus Mims, to talk about what doing it the wrong way looks like, to reiterate the standard in Terry versus Ohio. Pennsylvania versus Mims is an extension of Terry versus Ohio because there are two holdings in Mims. The first holding is that it's okay to get a person out of the car so long as they were lawfully stopped as a precaution for officer safety. That's the first holding. The second holding is, as Mims was getting out of the car, the officer noticed a bulge in his jacket. And so the court in Mims said because he noticed the bulge in his jacket, that qualified under the Terry standard as facts giving rise to the reasonable belief that Mims was armed and dangerous. And so the pat-down was legal, but Mims was not about armed and dangerous or a pat-down. And I've said that multiple times. Mims refers back to the Terry standard for the purposes of justifying the pat-down. So again, in this situation, you have Mims and you have Terry, but really abusing the Terry standard here because it's pretty obvious that they don't understand under what circumstances that they can pat people down. I don't know that this stuff is going to change. This officer's still there. I was able to get on the Tom Green County Sheriff's website, and they have some sort of Halloween event that they're doing, and I took a screenshot. I'll post it up here, and this guy's dressed in a Woody outfit. It looks like the same officer that's doing the interview. I might be wrong, so if I am, if this is a case of mistaken identity, then I apologize to whoever's picture I put up here, but it looks like the same officer to me. So I do think this officer's still on the force, but he really should go be a DNR agent because he don't know how to do anything except fish. I don't know that this sort of stuff is going to change en masse until we get rid of or significantly restrict qualified immunity, because these guys just understand that there isn't a whole lot that can happen to them as long as qualified immunity is going to rear its ugly head in every single case. But the Terry standard has been around since 1968, and the Mims standard, reiterating Terry, has been around since 1977. This really isn't something that isn't well established. So maybe somewhere along the way we get some hands slapped and we start seeing some changes. Just like I said in the last video, I do think that it is getting incrementally better, but I don't think it's getting significantly better. And I don't know that it will get significantly better until we do something with qualified immunity. I just don't know how that would happen as long as there's that blanket of protection for police officers to kind of do what they want to do and not have to worry about losing their house in a civil suit. Anyway, that's all for this one, guys. I hope you got something from it. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.